The immediate response from Washington tells you everything about how serious the situation has become. Military reserve forces were activated and positioned. Federal security zones around government buildings were expanded dramatically. Congressional leaders were brought into confidential emergency sessions. None of this was done for show. This was the government responding to a genuine constitutional emergency. When judges take actions like this, it means the normal checks and balances in our system are no longer working properly. Federal judges are specifically trained to avoid creating constitutional crises. They work extremely hard to keep courts separate from impeachment proceedings unless waiting any longer would actually threaten the foundation of our legal system. That critical point was reached inside a federal courthouse, done quietly through proper legal procedures, but with consequences that will reshape American politics. What came next was not disorder, but rather precise governmental control. Federal law enforcement officers physically removed every single attorney representing Donald Trump from the courtroom because they had committed perjury while testifying under oath. This was not about courtroom behavior or disrespect. This was about felony criminal conduct. 17 separate false statements were made that directly contradicted emails, computer records, and banking documents that the court had already obtained and verified. When the defense lawyers were confronted with proof of their lies, they did not stop lying. That specific moment changed everything. The trial stopped being just another legal proceeding. At that exact point, the courtroom became the starting point of a constitutional breakdown. Presidents have survived major scandals for generations using one simple tactic: delay everything. File endless appeals, create distractions, wait for public attention to move elsewhere. That strategy completely fell apart the second this judge compressed what should have taken years of political maneuvering into a legal decision that happened within hours. Time is no longer being controlled by political operatives. It is now being controlled by the judicial system. And when courts set deadlines, those deadlines do not get postponed for political convenience. This is the reason everything feels fundamentally different at this moment, not because of angry speeches or social media posts, but because the actual machinery of government has begun to function in ways it has not functioned before. What took place inside that courtroom next explains exactly why this situation escalated so rapidly and why it could not be stopped or contained once it started. Courts are institutions built on patience. Judges issue multiple warnings before taking serious action. They give lawyers every possible chance to correct mistakes and step back from dangerous positions. That entire process happened here over and over again. And each time, the defense made the conscious choice to continue lying under oath. Trump's legal team denied that specific communications existed, not just once or twice. 17 different times they told the presiding judge that certain emails simply did not exist. They told the jury there were no records to examine. They told the court there was absolutely nothing to review, but the judge already possessed those documents: emails, computer metadata, financial transaction records, and timestamps that completely contradicted everything being said under oath. When lawyers were confronted with this evidence, there was no attempt to clarify, no effort to correct the record, no acknowledgement of any mistakes. The false statements continued, and that is when the entire nature of what was happening changed fundamentally. Legal defense crossed the line into criminal behavior. Perjury is not a courtroom tactic. It is a federal felony, and the court responded to it exactly as the law requires. Federal marshals received direct orders from the judge. They walked to the defense table. Trump's attorneys were told to stand up, and they were physically walked out of the courtroom while cameras recorded every moment, while the jury watched, and while everything was documented in the official record. This was not done to embarrass anyone. This was law enforcement doing exactly what the law demands. In most trials, proceedings would have simply paused at that point. New lawyers would be appointed. The case would continue. But this judge did not move forward. He stopped the entire process, evaluated what had just happened, and made the decision to escalate. Because the problem was no longer just about lawyers lying under oath. The critical question had become whether those lies were directed by someone in authority, whether this was coordinated behavior, whether someone had encouraged or ordered these lawyers to obstruct the court itself. That question cannot be ignored when the person on trial is a sitting president of the United States. Once a federal judge determines that obstruction might be connected to executive power, remaining neutral is no longer legally acceptable. Courts cannot pretend the problem ends with the lawyers sitting at the defense table. At that moment, the judicial branch is legally required to protect the integrity of the entire system, even if doing so triggers consequences that go far beyond a single courtroom. This is the boundary that was crossed. The trial stopped being a place where facts were being determined and became the ignition point for a constitutional crisis, not because the judge wanted conflict, but because refusing to act would have meant allowing the judicial process itself to be destroyed. And that is why everything that followed could not have been avoided. To fully understand how significant what happened next truly is, you need to understand how extreme the judge's legal position had become. Federal judges receive intense training to stay away from politics with almost obsessive dedication. They do not make guesses about people's motivations. They do not suggest impeachment as a solution. They do not inject themselves into the separation of powers unless the only alternative is the complete failure of the system. That is the threshold this case reached. Once perjury under oath was proven beyond any doubt, the court faced a question far more dangerous than any individual lie. Was the judicial process itself being deliberately obstructed in order to protect presidential authority? When attorneys lie repeatedly in ways that appear coordinated, courts are legally required to determine whether those lies were directed from above, whether they served a larger strategic purpose, and whether the criminal conduct was part of a broader organized effort to interfere with judicial oversight. At that point, the judge was no longer simply managing a criminal trial. He was confronting a constitutional crisis happening in real time inside his courtroom. If the court had simply replaced the lawyers and continued with the trial, it would have effectively rewarded the alleged obstruction by allowing it to succeed. Creating delay would have benefited the criminal conduct. Remaining silent would have made this behavior appear normal and acceptable. And normalization is exactly how institutional boundaries collapse in democracies. Not through dramatic explosions, but through precedent, one small step at a time. This is why the judge took an action that no federal judge in American history has ever taken while a trial was still actively proceeding. He issued a formal judicial order stating that obstruction of justice and perjury represent impeachable high crimes and misdemeanors in direct connection with the conduct that occurred before his court. That specific legal language matters tremendously. This was not an academic discussion or theoretical analysis. This was a declarative legal finding. It established that the constitutional threshold for congressional involvement had been reached and exceeded. Then came the procedural action that changed absolutely everything about this situation. The court gathered all the evidence, officially certified it, organized it systematically, and transmitted it directly to the House of Representatives through formal legal channels. This was not leaked information. This was not a referral memo or a suggestion. This was an official judicial transmission, complete, sealed, and done according to law. Courtroom transcripts documenting 17 false statements, emails that the defense claimed never existed, financial records that contradicted sworn testimony point by point, body camera footage showing federal marshals enforcing the judge's order. By taking this action while the trial was still ongoing, the judge destroyed decades of presidential defense strategy in a single moment. The clock that presidents have always relied on, appeals, delays, political distractions, stopped functioning entirely. Congress was no longer free to wait and see what happened. The system had been officially activated. Courts only behave this way when they believe that waiting any longer actually poses a danger to the rule of law itself. And that is what makes this moment completely different from every presidential scandal that has come before it. The judiciary did not respond to political pressure. It responded to a threat against the constitutional system. And once that line gets crossed, there is absolutely no way to return to normal. The transmission of evidence itself was only the starting point. What shocked Washington was not just that evidence had been sent to Congress, but what that evidence actually contained and how completely airtight it was. This was not a partial record or preliminary findings. This was a closed investigative loop certified by a federal court, cataloged in detail and impossible to dismiss as speculation or political interpretation. Inside the transmitted package were complete courtroom transcripts documenting 17 separate lies told under oath. Emails that the defense insisted absolutely did not exist, delivered with full metadata confirming dates, recipients, and chains of custody. Financial records that contradicted sworn testimony item by item. Body camera footage showing federal marshals escorting Trump's legal team out of the courtroom for committing perjury. Public, procedural, and completely undeniable. And then there were audio recordings that were never intended to be heard by the public. Audio files in which Donald Trump is clearly heard instructing associates to ignore direct court orders. Separate recordings in which judges are threatened. These were not leaked materials from anonymous sources. These were official exhibits sealed by the court, authenticated through legal process, and transmitted as evidence. Once those materials entered congressional custody, plausible deniability completely evaporated. This is why the reaction across Capitol Hill was immediate and severe. Lawmakers did not need legal interpretation or expert analysis. They had documentation. They did not need partisan political framing. They had court-certified facts sitting on their desks. For decades, presidents have survived scandals by running out the clock, litigate everything endlessly, appeal every single decision, let public attention drift away, let elections change the political environment. That entire strategy depends completely on having enough time. The judge eliminated time as a factor by transmitting impeachment evidence while the trial was still active. The court collapsed what should have taken years of political maneuvering into a matter of days. Congress was no longer operating based on political convenience or caution. It was operating on a judicial timeline, and judicial timelines do not pause for political rallies, messaging strategies, or threats. This is when panic began to set in, not publicly in dramatic fashion, but institutionally among people who understand how government actually works. Because once evidence reaches this level of completion, delay itself becomes dangerous. Every single hour of inaction invites the question that no lawmaker wants to have to answer publicly. Why did you wait when you had proof? And once that question exists in the political environment, silence stops being a safe strategy. What fundamentally changed the atmosphere in Washington was not moral outrage. It was inevitability. The system had shifted from debate to mathematics. And when evidence reaches that level of clarity, the question is no longer whether Congress will act, but how quickly it can move. What many people outside Washington completely missed is that impeachment did not begin with the judge's transmission. It was activated by it. The machinery was already constructed and in place, waiting for the one thing that politics alone could never provide: court-certified evidence. Long before the courtroom exploded into this crisis, a House impeachment resolution had been quietly prepared behind the scenes, not rushed together in response to events, not reactionary, fully drafted with complete legal structure. 7 articles of impeachment, precise and severe. It covered bribery tied to emoluments violations, abuse of power through misuse of executive authority, obstruction of justice, contempt of Congress, violation of the presidential oath of office, and conduct linked to discussions about coercive military deployment that lawmakers privately described as tyrannical in nature. For months, that resolution sat dormant, waiting. It had political support, but not enough to move forward. Roughly 120 co-sponsors, mostly Democrats with a handful of Republicans. Leadership understood the political mathematics perfectly. Impeachment does not move forward based on outrage or anger. It moves forward based on numbers, and the numbers were simply not there yet. That changed instantly the moment the judge's evidence package arrived. The transmission did not add new allegations or accusations. It added proof, evidence that had been assembled under oath, evidence that had been certified by a federal court, evidence that removed all ambiguity and destroyed the final rhetorical defenses that lawmakers had been using. Once transcripts, recordings, and body camera footage footage existed as certified evidence, lawmakers who had been avoiding commitment were forced into a completely new calculation. Could they defend this on national television? Could they justify their silence if they were placed under oath? Could they explain standing aside once the documented facts were this clear and undeniable? For many members of Congress, the answer became obvious. Absolutely not. Names began appearing on the impeachment resolution rapidly and publicly. Republicans who had defended Trump just days earlier added their signatures to the document. Some issued public statements explaining their decision. Others said nothing at all publicly. But the count kept climbing steadily. By midday, it crossed the line that cannot be uncrossed in Congress. 220 co-sponsors, a majority of the House of Representatives. At that precise point, impeachment stopped being a political threat, or